Welcome to another episode of my 2 Cents, a Zambian case law podcast with me, your host as usual, George Chintang. Today's case is focusing on a certain constitutional law aspect or a constitutional law issue. Now, today's case citation is Arthur Lubinda Wina, Frederick Titus Chiluba, Veron Johnson Mwaanga, Akashamba Twale Wanika, Levi Patrick Mwanawasa, and others versus the Attorney General of the Republic of Zambia, 1991. The brief facts of this case stream from a decision that was made by the then President of the Republic of Zambia, where he called for a press conference. At this press conference, he mandated the then Times of Zambia, I think it was a Zambia Daily Mail, and other newspaper agencies to not allow the then opposition, the Movement for Multi-Party Democracy, to advertise in the newspapers. That was the directive. Now, the movement, MMD, I'll just refer them as to MMD. MMD was unhappy with this decision made by the president. They then decided to take up the matter to the High Court of the Republic of Zambia, challenging the decision of the president and whether or not he actually had the constitutional power to stop the opposition from advertising in the said newspaper. Now, when the matter came before the court, the decision that was made was that the president acted contrary, to the Constitution, that he should have never prevented the opposition party from accessing these public-owned newspapers. Now, the court, and allow me to quote from what the court said in their judgment, they said the directive was discriminatory of the petitioner and their cadres. I don't even know why he used the word cadres. The reason for the discrimination was that they held different political views from those of the president and his members. The newspapers which were given the directive are owned by the government. In light of these findings, the directive should be constitutional unless it falls within one of the permitted derogations. The first such derogation is consent of the victims of the discrimination. In this case, none of the petitioners consented to his being excluded from the enjoyment of his freedom of expression. The directive in question was not a written law, as it was not enacted by Parliament in order to attract the consideration of Article 22 to A, B, and C. So these discretions under the Act do not apply. But the directive fell within the in-performance of the function of any public officer. Let's move on to another provision, another part of the judgment which I thought was of importance, which I am trying to find now. So the court went on to also lament on the issue of journalism independence in these public institutions. They stated, this brings us to the next point, namely how newspapers of public ownership, such as the one this judgment has been concerned with, are supposed to operate. My considered answer to this question is that in cases of newspapers, they are supposed to be run on the basis of journalistic principles and ethics, free from any outside interference. These provisions dictate the coverage of all newsworthy events, regardless of the source of any such news. Anything less than this, and it is very easy for the general public to access whether or not a given newspaper is working according to the sound journalistic principles and ethics, is not accepted from a public news medium, print or other. In respect of other companies, the president may put his views to the board of directors it is up to the members of the board to either accept those views and adopt them as those of the board or to reject them. This is because not all the proposals made by a head of state may be in the best interest of a given company. Even public companies have to be run on sound financial basis. The case of Arthur Wina shows to a great extent how public-run organizations ought to operate. That they are independent of the government, autonomous, and have such great independence that they can actually tell the president that we are not accepting that suggestion. It also brings into the court to say public-owned newspapers can actually run contrary to the decisions of the president. The president is not them. They, like any other, have to be run on a sound financial basis. The board of these companies decide the fate of the companies. Further, the president of the Republic of Zambia is subject to scrutiny by every Zambian. If a decision affecting you has been made by the Republican president, you have the right to take him before the High Court and ask the High Court to squash that decision on various bases. We've seen this from the Arthur Wina, Frederick Chiluba situation, where they went to court and said, hold on, why is the government, through the president, preventing us from enjoying our rights? We are also being discriminated against. So apart from the freedom of expression and opinion, failure to allow opposition parties in a democracy to have their opinions heard is a discriminatory issue, and you can sue. This case was decided in 1991. We are in 2021, and we still see the issues at hand. The magnitude of this case was telling us that journalists also are not supposed to fall prey to control by political leaders in power. That journalists have the power to actually tell them that we're not going to be running this story. Thank you, but we are not. So the board members of these organizations run stories that ought to reflect that of the Zambian people. They must be accommodating. They must be independent. So they are quasi-governmental institutions. The case of Arthur Wina is pointing to the fact that journalists have a job free from interference. But the question still stands. Are government-owned institutions working as expected in the case of Arthur Wina versus the Attorney General? Because it's clear from this judgment, there's never been an appeal from this judgment. It's the law stating that government-owned institutions must be free to act how they feel, and that they act through their board of directors, and that a directive of the president shall not be considered as the law of the land. It is a recommendation picked up and can be thrown away. Also, the president is not immune from challenge or challenges from anyone. Anyone can come up today, if you are affected by that decision, and challenge it and ask that that decision be squashed. In this instance, the decision was squashed. The directive was set aside because it was unconstitutional. It also means the office of the president is not as powerful as we see it to be. That the office of the president is subject to control, subject to scrutiny to ensure you act within the perimeters of the law. And that the High Court is the court in our country given that responsibility to look at a matter and investigate it and see if the decision of the president is in line with the Constitution, if it's judicial review. However, with the coming of the new Constitution, there has been a bit of a problem with what amounts to judicial review, with the aspect that Article 28 gives rights to the Constitutional Court to hear breaches or violations of the Constitution. So it now becomes a bit entangled. So, however, that does not take away the principle in Arthur Wina, the aspect of journalism, professionalism, and also the fact that journalists of a state-owned institution are not supposed to run under the direction of any other person apart from the board of directors. The president cannot make a directive which the board has to quickly approve. No, the board must decide. Do they go with it or should they not go with it? And also, public newspapers must allow for the freedom of information from both the ruling party and the opposition, to allow those views to be there. If they prevent the opposition from giving their views, that is discrimination. And it's clear. I read a passage from the said case earlier on. So, in conclusion, we are seeing in the case of Arthur Wina, judgment made in 1991 that public-owned newspapers are not supposed to be controlled by anyone who is in government in any manner that they want. That any directive given should be constitutional, should be legal, and supported by an act of parliament, meaning checks and balances are also there. The government cannot act if they have not been given a power by parliament, and the courts will scrutinize you and to see that you've acted within the confines of the law. And if you haven't acted within the confines of the law, they will tell you. It is also showing that journalism has to be professional. Those of you that have friends who are journalists, refer them to this case of Arthur Lubinda Wina that strictly tells the journalists of a public-owned institution how they ought to act, that they should not listen or to be under the control of the government. They should run stories in their own right and what they think should be the stories to run. Lastly, I'll repeat this again. The president is subject to review of his decisions. It is a constitutional office. That office is not powerful beyond the Constitution. The Constitution is beyond the president. And that's why if you read Article 113, it will tell you, or if you read Article 1, that the state organs or offices created by the Constitution are bound by the Constitution, meaning you act in accordance with the Constitution, failure to which any decision made can be set aside. So that is all for today's case, talking all things constitutionalism and also the aspect of freedom of expression and opinion. Hope you learned one or two things. If you have any case that you want me to talk about, feel free to send me a DM on my Facebook, Twitter, and in the comment section. I think also on YouTube. Yes, I think we do upload videos on YouTube. Thank you very much for listening, and I hope you continue to listen, and I hope you've learned a few things. This has been your host, George Chintankwa Malipilo, signing out till next time. Bye.